This is the Constitution Committee in the House of Lords. We are today continuing our inquiry into the constitutional impact of COVID-19, and we are in particular taking evidence from Professor Susskind and Professor Dame Hazel Gen. We took evidence last week, 2 weeks ago, from the Lord Chief Justice, and we feel that the impact on the court and tribunal system is significant. I'd like to welcome our witnesses and thank them for coming, and start the questions by asking, in general terms, what the impact has been on the court and tribunal system and what the main challenges have been for those who are participating. Who would like to answer first? Professor Susskind?
I'm more than happy to. Good morning. The impact, of course, has been considerable. The court system is essentially a forum where people meet physically, and as physical courtrooms have shut very rapidly, the court service and the judges have had to adapt to a radically different way of working. And it's unprecedented, both in this country and worldwide. It is the case that many of the developments we're now seeing in place by way of emergency are developments that both the government and others had anticipated, but the speed with which the new systems and processes have needed to be introduced has been very, very challenging indeed. And so here and around the world, and I can speak about other jurisdictions as well, the challenges, as I say, been very considerable indeed. To dip down into a little more detail, and I'm not sure the length of responses you're wanting, so please do tell me if I'm speaking too much. But some of the challenges are cultural. It's just a very different way of working. Some of the challenges are technical. Many users are not familiar with these technologies. Some are procedural because our law has developed with a physical oral hearing in mind. And so it really is a very massive upheaval.
I think we will come on to some of those challenges and the impact on the participants. Lord Panic, you wanted to come in on this point, I think.
Thank you. Professor Susskind, I'm interested in your perception of how well the virtual system is working at the moment. My own personal experience of participating in remote court proceedings is that it's going rather well. However, I'm very concerned that the Bar Council yesterday, the volume of work has in many cases almost ground to a halt. That's their perception. I'd be very interested in your evidence, and indeed Professor Dame Gen's evidence on how the system's actually working. And also, can you tell us whether there is any work being conducted on a systematic basis to identify how the remote systems are working? Who is doing this work? Is it being left to people like you, Professor Susskind, or is there some official analysis of what is going on so that statistics can be provided to people like us so we can analyse the position?
Well, thank you, Lord Panic. There are a number of questions there. Overall, I would say the response has been remarkable in the circumstances for the reasons I've just suggested. The changes are fundamental and pervasive. Relative to other jurisdictions, for those of you who are interested, I would recommend the website www.remotecourts.org, where we're gathering together. We now have over 50 countries have reported on their progress. And relative to other jurisdictions, I would say we've responded and adapted very well. I think it's also fair to say that the response, however, has been different in different parts of the system. And so the criminal system has found it far harder to adapt, for example, than the civil system. The family system, a different story too. And I want to get back in a second to answer your question about who's gathering data. So better than I would have expected as someone who's been working in this field for many years, but there could be no doubt that there are large quantities of work that simply cannot be addressed by the courts because they require physical court hearings, for example, jury trials. How are we knowing what's going on? I think it's an interesting day to ask that question, because the Civil Justice Council is producing a report today that has interviewed more than, or received feedback from more than 1,000 lawyers, and overall, actually, the feedback I think has been fairly positive from them. The Family Justice Observatory, funded by Nuffield, has also undertaken a study. I don't know of similar studies in criminal, but I do know anecdotally that the tribunal system is gathering large amounts of data, and actually the tribunals in particular have been adapting especially well. The question you ask is terribly important, though, because it seems to me that we've got several challenges. We've got the challenge of getting through the crisis. We've then got the challenge of coping with the backlog. And then we've got the general challenge of improving access to justice, because we have a system that is widely recognized, a common with so many other countries, a system that doesn't offer sufficient and affordable access. And so my hope is that we can gather data about what works well, what doesn't work, where cases certainly need a traditional oral hearing, and what kinds of cases or parts of cases are we learning can more effectively or as well be done within the court system. So I and others are calling for more and more data to be gathered, so that both government bodies, independent academics and others can really scrutinize this experience. What we have is a major unscheduled pilot or experiment. I've been speculating, frankly, for years that these technologies could improve our ways of working, but there's no evidence from the future, as it were. We haven't had evidence, but now we have massive loads of evidence. We're not capturing it well enough, and I think we're going to get back to that later. But the question you raised, Lord Panic, is absolutely vital. And Professor Genn will be able to speak more authoritatively on the kinds of research that can and should be done, and the kinds of data that should be gathered.
Can I jump in?
I think that's an opportunity to bring in Professor Genn, both on the overview, and we will come to some of the specifics later. But I think the basic challenge that was being faced by the courts and tribunals was very significant. So if you could start by giving us a sort of overview.
Well, absolutely. I mean, I agree with Richard. It was the most extraordinary scramble. And you have to remember that our court system was starting virtually from below sea level with this. Although there had been a large courts transformation program, we were nowhere near along the way that we needed to be in order to meet these challenges. And I think that the people in the system, particularly the judiciary and the lawyers, worked really, really hard to make things work. And I'm not going to get hung up on technical difficulties, because there clearly were massive technical difficulties, and that's what you would expect with people unfamiliar with the technology, different kinds of technology, sometimes using telephone conferencing, sometimes using videoing, all sorts of things like that. So the thing I do want to say is to pay tribute to our judiciary, who I believe have done an amazing job with virtually no training, or in most cases, no training at all, to actually manage these kinds of situations. That includes both full-time salaried judiciary, but also the part-time judges that we depend on to make our system work, who also had no training and indeed no equipment. And I do want to make a point about that. So massive scramble, starting from a very, very low base, and everybody doing as much as they could. There has been no systematic data. There is no current real systematic data collection. It's really important. What I think this pilot has shown us, from the bits of information that we have in terms of the rapid reviews done in family, in civil, there's been a bit done in administrative justice, and from the anecdotal evidence that we pick up and that I pick up from my own Centre for Access to Justice that has been representing people in telephone hearings in between, is that there are both opportunities and real risks. In that there have been opportunities and risks, and that the pilot itself does not give us all of the information, because we all are aware, all of us who work at the kind of poverty law and the sort of poor law and the social welfare end of the system, recognise that there are people who have not been coming forward, or whose cases have been adjourned and held back, so that we don't have the experience of some of the hardest to help people to draw on at the moment. And for me, that's a really big gap. The kinds of things we need to understand is how different kinds of technologies work for different kinds of users, and by that I mean lawyers, judges, and different kinds of litigants with different capabilities, because it works differently. People can manage with different kinds of capabilities, different kinds of cases. Are you in a court? Are you in a family? Is it family hearing? Is it civil? Is it high grade commercial? Are you in a tribunal where you've got to know someone's trying to claim money back from you that you've been overpaid? So depending on the jurisdiction, is it an interlocutory hearing or is it a substantive decision hearing? What kinds of technology works best for that? And as I said, who's left out at the moment? And that's going to be a difficult thing to capture. And we need to find out who are we not reaching, because they are either intellectually excluded. We talk about digital exclusion, but there is intellectual exclusion, there is emotional exclusion, who's afraid of being on the telephone. I can't tell you how long I spent this morning just sorting out my laptop and all my bits of papers, getting ready for this. And I'm, reasonably capable person in most circumstances, and I've used technology a lot. So many different things that we need to understand. And this has been a sort of little experiment done at great speed. And I agree with Richard, where everyone has done everything that they possibly can. But we now see where the opportunities are. And there are some real opportunities there to make some things go much more smoothly, much more easily for certain kinds of people in certain kinds of cases, and where there are some real risks. And we have to make sure that going forward, we put in place a system that is going to capture evidence about what's going on and also capture information about who's not in there, who have we lost in terms of access to justice, or who do we risk losing when we come out of COVID.
Yeah, I think we will want to follow up on some of those specific points, but basically we can pay tribute to those people who've kept the show on the road at all, but we do have to delve deeper and find some of the consequences. Andrew, did you want to come in now? Andrew?
Can you hear me?
Yes, thank you, we can.
Yeah, thank you. I wanted to ask, are we yet in a position to draw some lessons from the operation of virtual proceedings during this current pandemic? And specifically on the point of data, Professor Genn, I mean, you've already said that there is a bit of a data vacuum in this area. And perhaps you could just be say a little bit more about what types of data and analysis we need to understand, what the benefits and shortcomings of virtual proceedings are. And just one final point, the CEO of the court service has promised to build excellent data systems into all new court systems. Can I ask both of you whether you're confident that this is indeed happening?
Okay, so the data that we've got, so we've got some data from the Family Observatory, which I've skimmed quickly. I've looked in detail at the report that's being published today for the Civil Justice Council, which gives some really useful information from lawyers, largely in commercial cases and in personal injury cases, from what I've looked at, in certain kinds of proceedings. And they've shown where it's worked well and where it's what kinds of technologies have worked well and what kinds of technologies have worked less well. I've got some information from my Centre for Access to Justice that has done some telephone hearings in welfare benefits tribunals, and I've just got 2 cases, but just to give you an example, because what's missing is information from the users, from the non-professional users of the system, and that to me is critical, because that's what the system is there for, that's what the system is there to serve. We need to know what is the experience of the people who are in the system, and in particular, we need to know what's the experience of somebody who loses in the system. Do they feel that they've lost by a process that they felt was fair, that they felt they could participate in, and where they felt they were heard and that the judge was listening to? These are the sort of aspects of procedural fairness. We also need to know information about outcomes. So what are the different outcomes using different kinds of technologies? So we need to hear about lawyers, we need to hear about judges' experiences, but very, very importantly, we need to understand the experience of different kinds of non-professional users of the system. And that includes both repeat players, so people who are quite used to going to court and being there, and those other people, the majority of people for whom being in any kind of court hearing or proceeding is a one-off event in their life. It's never happened before, it's not likely to happen again, and it may mean everything to them. And we need to understand what their experiences are. And just the two cases that I have been talking to my team about this week, and I pay tribute to them because they've been wonderful. So they had one person who was dealing with a welfare benefits case. She was offered a telephone hearing. She had been to one before, actually, and she felt quite capable, and she managed it, and she got a decision in her favour. The second person, when offered a telephone hearing, just said, absolutely not, I couldn't possibly, I would be too anxious. And part of his problem is anxiety. He said, I absolutely can't. And we were really worried about how he was going to do in that hearing. They had very late notice. Anyway, the point is that at the hearing, or at the point of the hearing, the tribunal decided this was not appropriate to be dealt with by telephone, or to be dealt with by telephone or on the papers, and that they needed to see the applicant. Now, that to me is an example of judges doing the correct sort of triage, looking at the situation and saying, this is not a case that is appropriate for either a telephone hearing or a hearing on paper. We need to see the person. We need to be able to get more information from them. And I think that will be critical in the future. And so the data that we need to collect will help us to understand which kinds of users are going to be able to manage better using telephone, using video, or even having a decision on the papers. We don't know that now. We don't have that information now. And the other question you asked is HMCTS collecting those data? Well, first of all, HMCTS can only collect data from people who enter the system, and so they can't tell us anything about those people who don't even engage with the system. And on the question of whether or not they are collecting all of the data we need from those who do engage with the system, I am not 100% sure that is happening. I've had very mixed messages on that. I've certainly been arguing for as long as I've been in the business of collecting data on the civil justice system. I've been arguing for better data collection about what's in our courts and tribunals, what happens to people and what the outcomes are. And frankly, we still don't have that information. We have better information on criminal justice than we do on civil or tribunals. Richard may know better about that commitment in HMCTS, but I am not currently convinced that the data that we will need to be able to answer the questions about who is in the system, who's using the system, what kinds of outcomes they get, and what kinds of perceptions they have of the fairness of the procedure by which they've been dealt with. I'm not convinced that we are collecting that, nor that were we to be collecting those data, particularly things to do with demographics, nor would we have clues about who we're missing, our hardest to help, some of the hardest to help groups who at the moment are not engaging with the system.
Yeah. Professor Susskind, do you want to put some light on this as well?
I wondered if we might just take a step sideways or backwards just to be absolutely clear in concepts here, because there's all sorts of terms flying around here and elsewhere about online, virtual, digital, electronic hearings. So let me try and pass along to you the classification that I gave to the senior judiciary to try and bring some kind of clarity and consistency. So we have physical courts. I call the alternative remote courts. That perhaps is an unfortunate term, but the important thing here is that there's three subcategories. There's the idea of an audio hearing, there's the idea of a video hearing, and there's the idea of a paper hearing. Now, an audio hearing is essentially a hearing by telephone, and there can be two sorts. The first sort is when there is actually a physical hearing, but some people are participating by phone. And the second sort is when everyone is participating by some kind of telephone conference. Similarly with the video hearing, not unlike the hearing we've got today, this I would call a full video hearing because everyone is participating by video. For a long time, we've had partial video hearings where there is a physical courtroom and there are proceedings and some participants are engaged by video link. And thirdly, there's the paper hearing where arguments and evidence are submitted in paper form alone and the judge responds in kind. So they're the three broad options: audio, video, and paper hearing. Now, the previous question asked, what are we learning? I think one thing that's emerging quite clearly is that the video hearing, in broad terms, is better than the audio hearing. There's a lot more information conveyed. I think, for example, if we were all on an audio call, we would have a less rich experience. I can see your faces, I can see your expressions. A second feature, I think, or a second finding is that it's very tiring to do these hearings. Judges who are used to sitting for 2.5 hours in the morning and the afternoon are reporting that actually more breaks are needed. A third thing is emerging is there needs to be ways for lawyers and clients to communicate with one another during the hearings, because they're not sitting together and they're not able to write notes or talk to one another. A fourth thing that's emerging is that it's quite hard to handle cases where there's large bodies of documents involved. We don't have good document management systems to support these kinds of hearings. I think generally, many people have been surprised at how effective, for example, a video hearing can be. I think there's another finding is that, or conclusion emerging, is that partial hearings are not so effective and throw up questions of procedural fairness. That's to say, if some people are in a physical courtroom and others are communicating by video, there does seem to be an imbalance there. And this is a remarkable thing. It's not just for courts, it's for Parliament, it's for meetings generally, that I can imagine a world in which we actually are back in buildings, but when it's a video hearing, we're all doing this from our offices rather than getting together. So some early findings are emerging, but let me agree with Hazel, who was saying we just don't have the data. And I hesitate about this because I really do think the court service, under all sorts of pressures and with reduced resources and in the context of this seismic shift that I've mentioned, is really doing remarkably well. And so it's a lot to ask to say we have to capture data as we go along, but we really do have to ask that, because if we are to use this experience to help reform our court system, to take the best of this new way of working to improve access to justice, we simply must know more. Now, this is well dealt with by the Civil Justice Council report, which shows that to gather a lot of the data to do that work about the cases, a lot of that had to be done, as it were, by hand. It involved desk research rather than simply a printout of what hearings there were, where they were, what technology was used, whether it was open to the public, whether or not there were technology issues, what the outcomes might be. That information is just not available in data sets today. And we have to do everything we can to try and encourage HMCTS and everyone who's working in the system to be capturing data, so that scholars like Hazel can analyze it every which way and come out with evidence, so that for the first time our future thinking about technology in the courts will be evidence-based. We've never had that opportunity before. But we've got to move beyond speculation and anecdote. We've got to move beyond personal preferences of individual participants to something that's far more systematic. We've got to have the rigor of the clinical health trial, because this is the future of our justice system, in my view.
Thank you. Thank you. Baroness Folks, you want to follow up probably from some of those comments that we've been hearing?
Indeed, yes. We've obviously looked at an enormously wide field with great implications. Could we come back for the moment to the short term? What activities, what decisions should be taken in the immediate term, short term, for, say, the next 6 months? What resources, what decisions should be made to help the system short term?
Oh, well, I'll go. Shall I go first?
Yes.
I'll say what I think, and then you can correct me, Richard. So I think we need to try and sort out the technology. And that's a practical thing, but we certainly need to sort out the technology. And as Richard said, to work, to get things to telephone conferencing, the video things to work as well as they can. And I agree that, and I think talking to judges as well, I think that although video conferencing is tiring, it's much better when you can see the parties. But that does raise questions for the parties in terms of their access to equipment. So we need to sort out the technology. We need to focus on collecting the evidence, because we need to start putting those systems in process now. If we're going to collect the evidence, we need to do that now, not in 6 months' time. We need to get those systems up and running to help us to understand the opportunities and the risks. I think we need to be training the judiciary in all jurisdictions, first of all, on what is best practice. They haven't had time to do this, but there needs to be a program of training for the judiciary so that they understand what's best practice or what's working well in their jurisdiction for certain kinds of cases. And they need this. Also, they need to understand how different technologies work for different kinds of litigants in order to be able to do triage properly, because we're leaving it to judges to make the decision as to what form of hearing because they can determine, preferably you'll get consent of the parties, but they can determine which cases are going to be dealt with by telephone, by video, or on the papers. And those are big decisions. And so they need to feel confident about the information that they're using to undertake those that triage. I think the profession has a big job in training representatives to think about how they manage different kinds of hearings, how they work with their clients, particularly when you're not in the same room. And I've had several people say that it's terribly difficult to have when the judge makes a suggestion in a hearing, you're not all in the same room. How do you have a quick chat with your client as to what to do? And it means you need about 3 or 4 devices so that you could be WhatsApping somebody while you're on Zoom or while you're on the telephone, whatever it is that you're doing. So there's training for judges, there's training for representatives, and as I said, collecting the evidence, getting ourselves in a situation now that we can collect systematic evidence, that we can start to analyze it so that we can be constantly feeding it in kind of in the way that we have been with dealing with a pandemic, so that we're learning all the time as we go along, improving our processes, so that we're constantly improving our processes, refining them in order to deliver the best quality of outcome for everybody involved in the system, to deliver procedural fairness for the litigants and substantively just outcomes for the parties, because that's what people want from the system. And our system has been good at doing that.
Professor Susskind?
Well, thank you, Baroness Fuchs. I think it's a terribly important question, because although we are focusing in some of our discussion about the longer term, we have a court system to keep up and running just now. One of the difficulties here is it's hard to change the wheel in a moving car, as it were. You have this major machine moving forward, and so, and it might surprise people when I say this, I think we have to be quite modest in what we're trying to achieve technically to keep the system up and running. For me, to answer your question about the short term, it's about stabilizing and improving the rather ad hoc systems that have understandably been put in place, so to minimize disruption. I think we have to watch that we're not too ambitious in bringing in new technologies. I think it's important that we increase confidence across the judiciary in using the initial basic systems, that we train, as Hazel suggested, that there's support available, technical support, that there's standardization of practice, that we are gathering user stories, so there's a community of judges who can speak to one another about what works and what doesn't work well. Hazel's absolutely right. We need clarity on the question of allocation, which kinds of cases must be reserved for physical hearings, which kind of cases go to audio or to video or paper hearings. There needs to be standardization of that process. There needs, I think, to be simplification of the protocols that have emerged. There have emerged, and it's been hugely impressive what the judges have achieved, a whole body of new practice directions and protocols, but quite overwhelming, I would imagine, if you're a judge on the ground with a large caseload working in this rather alien environment. And so we need simple, practical, punchy guidance for very committed individuals who find themselves slightly at sea. I know the temptation will be to continue bringing in new technologies and evolve, but I'd like to see stabilization of the current systems. I don't believe, unless that some miracle comes about, that this is going to only last for a few weeks. I think that it's 6 months or a year and so forth. So this focus on minimizing the disruption by making the most of the technology which we currently have. And if there is a lesson that's emerged, is that we can actually go quite a long way using the existing technologies. So we have to make a user community, part of the judges and part of the lawyers, more comfortable with, to use the cliche, this new normal.
Professor Genn, did you want to come back in on that, or can I bring in Lord Farks?
Could I just add something very quickly that I forgot to mention, which I do think is terribly important, and that is that in the however many months while we're stabilising and sorting this out, we must think about the needs of the advice sector, which has been pretty much savaged by cuts to legal aid and those kinds of things. That they are going to need support in order to provide the support for people who are going to, because as Richard said, we're going to be going through a difficult period for a long time. So we need to not forget that that's that part of the sector, the not-for-profit legal advisors, social welfare legal advisors need assistance in providing support for people who can't help themselves.
Thank you. Lord Farks.
Good morning. Good morning. I should declare an interest as a practicing barrister, and members of my chambers have been grappling with the problems that have been thrown up by the coronavirus and various remote hearings. And I think mostly it's been successful. One colleague did a hearing in the Supreme Court, which I think worked pretty well. But of course, that's a very contained experience. What I'd like to ask you about is that there are variations, of course, in the challenges that different type of hearings throw up. I, for example, was due to do a 10-day trial in July, which involved witnesses whose credibility was likely to be an issue. Now, I'm glad to say the case settled, but one of the reasons it settled was because there was real uncertainty, I think, on both sides as to how easy it was going to be to feel confident about the outcome, having regard to the fact that none of the witnesses were going to be present. It was all going to be a remote hearing. The High Court could not offer that, a hearing with anybody present at all. The hearing would have been put off for a year or so, which would have been effectively a denial of justice. And this is an important constitutional issue for us, that there are some cases, notwithstanding the fact that this has been a successful, largely successful, but unscheduled pilot, that really that can cause problems and real questions for us. I wonder if either of you would like to comment about this.
Would you like me
to? You can answer. I mean, I think that might be an example of the kind of case where you would say this needs a face-to-face hearing, but is it going to be feasible in the time? I mean, I think being able to see people on video is better than nothing. And I understand the importance that people put on assessments of credibility, but and there are debates about that. But certainly, being able to see people, being able to pick up visual cues, I think is very important. It's important for judges. It will be important for juries as well. I think that's a huge practical problem. And I think running a very long trial remote is going to be difficult. But I don't know, Richard, you may know more about what the plans are in criminal justice, those kinds of things.
I wanted to comment rather on the issue of whether or not one can take evidence, and the experience, as many judges and barristers have said, you need to see the whites of someone's eyes. And it's quite interesting. I don't really want you all fiddling with your system, but we're on a system called Zoom just now. In the top right, there's something called speaker view. Now, I suspect what you've all got before you is we appear like a series of tiles. But if you go into speaker view, you may not wish to do this, and you press the button, I suddenly appear, I know it's grotesque, but I suddenly appear in full Technicolor, as they used to say, all over your screen. And the difference between looking at me as, frankly, a postage stamp on the screen as opposed to filling the entire screen is manifest. And what's coming through, and this is a global experience again, look at remote courts worldwide, is that many attorneys from the United States and lawyers from around the world are reporting that actually they find it remarkably effective and they can get nearer to the whites of the eyes, not just metaphorically, actually, than in a courtroom. And so I don't think we should make assumptions. We need to clearly have systematic data on this, but I don't think we should make assumptions that if evidence needs to be taken, or if there's questions of credibility, that there is no way this can be achieved through the video hearing. And also in lower value cases, there's issues about whether or not it's proportionate to hold a physical hearing in any event. What's emerged is that as a generality across the world, these systems, these video systems, seem to have worked quite well with large, complex commercial cases. So I wouldn't immediately say that that's a category that needs to be reserved. At the same time, this is something we'll perhaps discuss a little later. I can imagine that during the course of a dispute, sometimes the judge will say we need to gather together physically, and on other times they'll say, actually, it'll be sufficient to have a video hearing on some particular issues, just in the same way as I think Hazel's judge said, we need to have a physical hearing. The judge will have discretion to determine, and presumably the parties will have views in this too, to determine whether or not the hearing mechanism is appropriate. But I do find it fascinating, the feedback of those who are expressing surprise that actually you can get a real sense of a person's credibility, of their demeanor, by looking at them in quite a high definition screen where the video is quite close to their face. What I do accept is there's a whole bundle of other body signals, and you, for example, Lord Faulks, as a barrister of many years standing, will have this instinct from the way someone's standing or the set of their shoulders. We lose a lot of that, but you could say this will emerge as the new craft of the future, the online barrister who can read the signals better.
Right. Baroness Corsten, do you want to come in now? Baroness Corsten?
Bottom left button.
Can you hear me now?
We can. Thank you, Jean. Yes.
Okay, thank you. Right. For what types of proceedings is an online dispute resolution process an effective or sensible addition? What are the implications of using such a process?
You go at this first.
Professor Gent?
Sorry. I think that ODR processes can be very useful, particularly in commercial cases where settlement is a real possibility, where settlement negotiations often take place anyway. I think it could be useful in small claims where there's some kind of reasonably rough bargaining power. So I think that could be a useful add-on. And actually, interestingly, I think sometimes dispute resolution processes can be helpful in even things like some complex tribunal issues where you've got some very difficult issues to sort out and where reaching some kind of a settlement rather than having a binary decision can be quite helpful. So I think that there will certainly be cases where the addition of an online dispute resolution process would be a helpful supplement or the opportunity to do that, so long as people understand the significance of what they're opting into or what they're involved in and what it means for the eventual outcome. So this comes back again to people's levels of capability, what kinds of people in what kinds of cases, do they understand the implications, and can it be useful? I'm sure Richard's got quite strong views on this. I'm quite agnostic on ODR.
Professor Susskind?
Well, Baroness Carson, thank you for that, because I do think this goes to the nub of something we're not very clear on yet. And it's something I've written a book about online courts, and it's one of the unanswered questions that we have all these new facilities. And it's not yet clear to us which types of problems, which types of issues are best dealt with physically and which are best dealt by some kind of online mechanism. I think if I understand your question, if I'm answering it correctly, or appropriately. I think the early thinking is good for preliminary hearings, good for case management meetings, good for interlocutory hearings, good for trials perhaps where there's not much evidence, good for trials perhaps where there's not huge amounts of documents. There's a general view on grounds of proportionality that this kind of process is good where it's very sort of high volume, low value cases. But I know that both Hazel and I, to some extent, are sounding like broken records on this, but we don't really yet have the data. I think in a few years' time, it'll become clear, and we'll look back and think it's unbelievable we used to assemble in a physical courtroom to have this 10-minute hearing, or for this case management discussion, or for this quite straightforward case, and so forth. We want to build evidence on this. My own sense is that whereas 6 months ago, I was speculating that there were benefits to be gained, a more accessible system, more efficient system. As I say, in the categories I just mentioned, the evidence is suggesting that an online process makes sense. That's not to say, and none of this is to say, as I say in my book, that some kind of online hearing is better than appearing physically before the finest judge in the land. It's to say that we are running a public service here, and it has to be available and proportionate. And this experience is suggesting to us there might be a different way of disposing of some of the massive caseload. And more importantly, as Hazel refers to, the many disputes that we have out there in society, they don't sniff the court system because people regard it as unaffordable, too forbidding, inaccessible, or it's not part of their world. Wouldn't it be wonderful if we had a service that was genuinely part of people's world, allowing, of course, for computer literacy and confidence in using these systems and so forth?
Not just computer literacy.
Sorry, Professor, again, did you want to come in again?
Just to say, not just computer, it's not just about computer literacy. The ability to take advantage of online proceedings in any way requires, or indeed to take advantage of any proceedings, requires not just computer literacy, but literacy in general. And we have very high levels of low literacy here, people for whom English is not their first language. We have different capabilities in terms of comprehension, and sometimes people don't even understand the significance of ticking one box rather than another in terms of legal outcomes. So there are lots of questions to be asked. And as Richard said, we're just at the beginning, but I hope that in a few years' time, we'll have much better evidence about how remote systems can contribute to our system of justice, and where we absolutely need to continue with face-to-face hearings, and to know why we need to do that and what it delivers. So what we gain from face-to-face hearings, what we might gain in terms of a whole range of things from using remote hearings. And I'm sure that in the future, we will have a mixture, and I hope that it will be well calibrated to the needs and capabilities of the users of the system, and in particular the non-professional users of the system. And of course,
I see that Lord Hennessy wants to come in on this, but I know that Baroness Drake wants to as well. But Lord Hennessy, do you want to make a point? And then Lord Howarth.
Thank you, Chair. Can I pick up on Hazel's point about legal outcomes? Because it seems to me what's lurking behind our discussion in every aspect this morning is, will it change legal outcomes, this move to digital and the distancing of witnesses and so on? Because I have to confess, I'm a stranger to the world of the courts because I've led a very sheltered life. And it's many years since I was a juror. But it seems to me that the quality of outcome could be changed. In fact, outcomes could be changed if people lose those intangibles that you were both so eloquent about, the whites of the eyes, picking up the visual signals. But it's the same question lurking behind this one, and there are several other questions that we've still to ask, is do we think decisions will go differently because of the new world we're moving in than they would have done if we were still in the old?
I think, sorry, can I answer? I think this is a critical question, and I'm afraid that a lot of discussion around this focuses on process and not on outcome. The purpose of the justice system is for people to achieve an outcome. And the people who should be most in our minds are those people who don't get the outcome that they wanted, and they need to leave that process feeling that they've been through a process that was fair, where they participated, where they were heard, and where the judge was open-minded. And there's a question for me about how we deliver that sense through various kinds of remote hearings. But we don't know, unless we collect the data, we won't know whether or not different kinds of hearings will deliver different kinds of outcomes. And it's really important. And just some of the work that I've done in the past shows that if you go to a tribunal and you opt for a paper hearing, your chances of succeeding are much lower than if you go physically to a hearing. Now, that's been known for a very long time. And the question is why? Is it because the judge can see the whites of your eyes, or is it because at the physical hearing, the judge can gather more information that wasn't available in the papers? So we need to understand those kinds of things. But absolutely, the question of substantive outcome is very, very important, just as important, more important possibly even in a sense of than the process questions, because you can actually enjoy a process and think, yeah, that was really great, but actually you lose, you don't get the outcome, that you don't get the thing that you were legally entitled to.
Right. I'm going to bring in Baroness Drake because she wants to follow up on some of those details. Then I'll bring in Lord Howarth, and then I'll come back to you, Professor Susskind, if that's okay.
Yes, okay.
Baroness Drake.
Oh, hi, good morning. I take the point that one needs the data to move beyond speculation, but we are keenly interested in the impact of virtual proceeding on different groups, and you're beginning to see that in some of the supplementary questions that we're putting to you. But could I seek your view on the impact of virtual proceedings for litigants and access to justice more broadly? And in the light of those views, what systems and supports you think will be required to protect that access to justice?
And Lord Howarth, you wanted to follow up on similar points, maybe? Could we let Lord Howarth in, please, and unmute?
It's Lord Howarth you want, not Lord Howell.
Lord Howarth, yes.
Yes.
Alan, can we unmute Alan? He seems to be frozen at the moment.
Hello?
Alan, yes, please.
Have you got me?
Yes, thank you. Your turn.
Okay. Three very, very quick questions arising out of what's been said, if I may. Both our witnesses have praised the judiciary for their alertness and their committed response. I think Professor Genn mentioned that they had to do this without training or
this is
equipment. Am I right in thinking, though, that...
Sorry, can we get some technical assistance here? Is anybody able to hear what Lord Howarth is saying?
I heard part of it.
No.
Perhaps we can
modernisation program. Hello?
Lord Howarth, we only heard the odd word. Can you just check? Maybe we can come back to you. And I'll let Professor Susskind in first, and we'll try and sort out the technical difficulties. Professor Susskind, do you want to take up the points that Baroness Drake was raising and we were talking about before?
Yes, I did want to also, if I could respond to Lord Hennessy's observation. I would never be interested in this if I thought that there was a sense in which the decisions of a non-physical court system would be unfair. I think we need to determine those kinds of cases where either the fairness of the decision is equivalent to the traditional system, or even that it outperforms and improves in the system. But we actually do have empirical evidence in this. We can look, for example, at the Civil Resolution Tribunal in Canada that has done extensive research on the issue of whether or not the fairness of the decisions, the fairness of the process. There's similarly detailed academic studies going in the United States on this as well. And the early evidence is very encouraging. I fully accept there will be some cases where it's hard to imagine a just outcome without a physical congregation. But I think we have to be open to the evidence which is suggesting that in many cases we can indeed achieve justice through some kind of online proceeding. There's another kind of justice. There's an issue here, though, and I could bore you senseless with I think there's 7 kinds of justice, in fact, at issue here. But another sense that's really important is the question of distributive justice. We live in a society, and we should collectively be ashamed of it, in which access to justice is given to very, very few indeed. And it seems to me having a perfect system for a very small number of people, a ceremonial Rolls Royce that a few can afford, where everyone else is left to walk, is unacceptable. So if we can indeed develop a system that's perhaps rougher at the edges in process terms, but delivers fair decisions, that's something we should be open to. And that links into the next question about the impact on litigants. For me, this is about accessibility. Isn't it unbelievable, looking worldwide, that 46%, only 46% of people, according to OECD figures, of people have access to lawyers and courts. More people in our world have access to the internet than have access to court systems. And actually the same is true in this country. And it is hard to avoid the conclusion that our current system is too expensive, too time-consuming, too combative, unintelligible to the non-user. And so we have to be so terribly careful when we're taking pot shots at virtual options that we remember that the status quo itself is deeply defective.
Perfect.
It's one of our collective challenges, ladies and gentlemen, is to improve the current system. And there is no point in comparing online courts to some idealized, perfect model of the delivery of justice that doesn't exist. Our current system, I argue, is in a parlous state. And so we should be looking here for improvement rather than perfection. And I fully accept, and Hazel's written and spoken so compellingly on this in the past, that there are a group that we have to be deeply concerned about, people who are hard to reach, frankly, in the physical system, or using online options. But we do have a problem of accessibility. People can't afford legal advice, and the court system in turn is not open to them. And we also face a related issue that we'll see the emergence, and we are already seeing this, of online private sector alternatives to dispute resolution. And in a way that's quite attractive. But that's to say people can quite quickly have their disputes resolved by some kind of electronic form of ADR, an expert determination, a mediation or the like. But it does worry me that if people's first port of call when they have a legal dispute is not our public court system, the rule of law depends, I think, on the daily affirmation through the delivery of authoritative binding decisions by our judges. If the market provides a more desirable alternative, we have a system we should rightly be questioning. And so my life's work has been to how can we increase access to justice by the use of precisely the kind of technologies that have been foisted upon our system over the last few months. So let's learn from this experience, because there's a related point here that there are quite a lot of judges and quite a lot of lawyers who are of the view that once, and we hope it's so very soon, once our lives can return to normal, then we just pile all the cases back into the old physical court system as well. And I think this view is deeply flawed. I think we have to learn from this current experience. As, for example, in medicine, people are understanding that consultations by GP, by Skype, work out in many cases. We have to learn from this experience and see if we can capture what works well, understand what doesn't work well, and meet the backlog, meet the access to justice system challenge, rather, using these new emerging systems. So I should also say, and it's the data point again, if you have a look at the report that's out today in the civil justice system, we only have a handful of responses from litigants in person. So we really do need more information about what it's like to be a non-legal, if I can put it that way, user of these remote courts.
Thank you. Professor Genn, did you want to come back in on some of the points that Baroness Drake was raising?
Just to say quickly that I'm not suggesting that we're aiming for some kind of perfect system that we don't have at the moment. What I'm worrying about is, what I need to know is that we haven't actually reduced access to justice. and that hopefully we have increased access. So what I'm concerned about is that there are people who have been capable of accessing the justice system now who actually are going to could be excluded, and that would be a very poor downside of this. And our hope is that we would actually be able to attract more people in. And only time will tell. It is quite clear already from the evidence from the Civil Justice Council rapid review and from the intelligence that I'm getting from people on the ground, is that people aren't being able, the kind of regular clients at the lower end of the income spectrum are not making the inquiries that they would expect. They're actually not being able to access the forms of advice that they would have done in the past. So I'm not arguing that we're going for a perfect world. What I'm saying is I don't want to lose the level of access that we have now, and preferably we want to be able to find ways of increasing it.
Thank you. I'm sorry that we can't get Lord Howe's connection sufficiently good to bring him in. So I'll move on to Lord Cherbow, if we can connect there.
You need to unmute.
Can you hear me?
Yes, thank you.
I want to just focus on a couple of points that have arisen in the course of the discussion in a very practical way. I mean, we've had a clear explanation of the hybrid, the nature of the present proceedings, the different technologies, the hybrid courts and so on. So one question is, what have been the practical problems in the current period which have perhaps made the administration of justice less effective? Secondly, in particular with focusing on the non-professional participants, what practical help can we give to those people in the present period? And thirdly, if over time we move to a much more effective and smoother system of digital remote courts and systems, what might be the practical advantages of that over the old system?
Who would like to go first? Professor Susskind?
I'm happy to have a go. Thank you very much, Lord Sherborne, for that question. Practical problems. A lot of the value we just saw it exhibited with poor Lord Howarth a second ago, that sometimes there's technical difficulties, and you're fortunate in having, we saw it even in the introduction to proceedings today, that you had some kind of technical support. But the court service is very stretched, and we can all envisage a future, and it's part of the vision of the court service in the future, that before you enter some kind of remote court, there's a waiting room, your connection is checked, procedure and process is introduced, and that would raise the level, I think, of confidence that is a more professional environment. So there have been technical issues that will be overcome in the future when, for example, the technical connection is constantly being monitored and people are given assistance in how to use these systems, which buttons to press. We have videos today which help people who are preparing for a physical court hearing or self-represented. We can similarly, on YouTube or wherever, have systems that would help people track through how to use what is, after all, a basic app. Overwhelmingly, most people in the country use kind of remarkably sophisticated technology in their handheld phone, and they navigate their way around. They do so because there's help available, and we need to make that practical help available. The other practical problem, you may not think this is practical, but there's a cultural issue, and there is no doubt that some people instinctively, viscerally are nervous, judges, for example, about jumping to the video hearing, and many have defaulted to the audio hearing. The phone is the comfort zone, the video hearing otherwise. And so we have to recognize, and I've done detailed research on this, so I don't say this lightly, but as a community, the legal community is technologically conservative compared to other professions, compared to doctors, compared to auditors, tax advisors, and so forth. So we've had this very practical problem of a user group who are by and large quite conservative when it comes to technology, being asked overnight to conduct their daily activity in a foreign environment. You asked about non-professional users, and in fact, I think I've covered that. I do think we need to have practical help online, but also, and I think the government's working along the right lines here. I'd be interested to hear what Hazel's got to say. There's a whole program called Assisted Digital, anticipating that some people might not have the technical skills or otherwise the competence, confidence, abilities. There will be and should be human beings available to help those who need assistance, because it's not just judges and lawyers who are apprehensive of this new environment. It must be terribly forbidding for non-lawyers to be appearing in this environment. Whether or not it's more or less forbidding than appearing in a physical courtroom is an interesting, I think, question that we can ask ourselves. It seems to me there is lots of practical help we can give. Hazel mentioned earlier best practice. We've got to, and it's not just in this country, around the world, pick up all sorts of tips about what works and what doesn't work. Very quickly, for example, people were saying use WhatsApp when you're communicating between lawyers and clients when they're communicating on the line. Set up a conversation so you can have a dialogue at the same time. I picked that as a tiny instance of something that emerged within a couple of days as a sensible thing to do. We need to capture all of that. And wouldn't it be great if judges had available at their fingertips, and similarly non-lawyers, just the top 20 tips for conducting a hearing online? It would help immediately.
Thank you. I'm going to bring in Professor Genn and then move to Lord Howells, and then we'll try Lord Howarth again to see if that connection is better. Professor Genn.
Yes, thank you. Can I just add something on support for non-professional users? It isn't just a matter of technical, being able to use an app on a WhatsApp. Clearly, there are people who have difficulty uploading documents, so they need to be able to upload documents. And remember, if you've got somebody, even if they're on the telephone or if they're doing this sort of thing, if they're on their own, they need support. They're told in the instructions that they're not supposed to have anybody in the room with them. So if they're supposed to be on their own, they're only allowed to drink a glass of water and things like that. So there needs to be technical assistance available if they can't get their documents up. In fact, I've spoken to judges who say they have 3 different devices working all at the same time so that they can read their documents on one thing and all the rest of it. So how many people are going to have that? If they've even got an advisor, let's suppose they've got someone from the CAB or from a law centre who's advising them, they won't be in the room with them. How do they communicate with them? It may be after lockdown that they can do that. I do want to say something positive. The other thing is about, is there more or less sense of foreboding than sitting outside of a courtroom? Well, I've sat outside courtrooms and tribunals with people waiting to go in, and it is quite nerve-wracking, but they can have someone with them sitting there and they can chat. When you're sitting on your own in your kitchen or your sitting room in front of a laptop thinking, is this going to work? Is it not going to work? What's going to happen? Or waiting for the judge to call you on the telephone. Believe me, that can be quite anxiety-inducing. The people for whom I think this could be a real benefit are people with disabilities who would find it difficult to travel to a courtroom, who will find it much easier, much less stressful, in many ways, physically less stressful, to be able to do things at home. But they're still going to need that technical support. They're going to need the right kind of equipment, and they're going to need to be able to understand what to do and expect. And the information available online, which I have looked at for users and potential users, is tremendously dense. It's all pretty much, as far as I can see, the written word, and you have to plow your way through it to work out what's going to happen. What am I supposed to do? Can only drink water, mustn't have anyone else in the room, mustn't record, all those kinds of things. It may be that over time we can produce good videos and YouTube things. I learned how to fix my dishwasher the other night by looking at something on YouTube. So we can all learn things from watching how things are done. So that I'm sure there are improvements that can be made, but in the immediate next 6 months to a year, there is going to be there needs to be a lot of emphasis on how we provide support for individuals who do not have high levels of capability and who have never done this before. That's what we need to remember.
Thank you. Lord Howells, would you like to come in now, please?
Thank you, Chairman. Dame Genn, you've made the fascinating suggestion that this world of online proceedings may take us away from adversarial court battles and all that to a more inquisitorial system. Well, of course, if that's the way we go, that changes everything, doesn't it? The way our cases are conducted, the whole sort of flavour of English and British law. And I just would like to hear your views on that. I think two questions arise from it. One, if this is the way we're going, inquisition rather than adversarial challenge between great QCs and so on, does that require completely new skills and characteristics in our judges? Because it's a different way of conducting things. Secondly, really, sorry, just if I can add to that while I've got the floor, does this mean that, in fact, we're going to see far more dispute settlement outside courts and go rather, in global terms, the way of, say, Japan, which has many fewer court hearings and indeed many fewer lawyers, or go the other way towards America, where the whole place is swamped in litigation the whole time, and one can hardly move without some kind of court involvement? So those two questions, please.
I think that the point that I was making is that particularly in relation to the idea of online continuous hearings that have been proposed for tribunals, where tribunals can look at the information, see what information is missing, and then ask people for additional information, so that not everything hangs on what happens at the hearing, so that that process can go on. I thought actually could be quite helpful for litigants in person, because it gives them the opportunity to produce additional information that they haven't managed to do. But it does change the character of proceedings. It means, and I think that whatever happens, whether we have online continuous hearings, which I've heard are actually very expensive and very time consuming to do, Richard may have a view on that, moving from face-to-face hearings and the sort of set piece hearing where everyone congregates together, and the way that we take evidence may mean an adaptation in everybody's behaviour. So it means that lawyers are going to have to adapt to different kinds of procedures, and that judges are going to have to adapt to dealing with evidence in different ways, which is why I said that we really need a good training programme and to learn from practice. Did you want to say something, Richard?
Professor Susskind, do you want to mention your reaction to Lord Howe's point about moving towards an inquisitorial system?
Yes, I did. I've given a lot of thought to this. It raises a broader and really important question. Is the idea here that we take the existing English justice system and drop it into Zoom or some kind of electronic environment, or do we take the opportunity, as I and others have been arguing for some time, that the role of technology is not to automate and somehow perpetuate our old inefficiencies? The role of technology is surely to allow us perhaps to resolve problems in new and different and improved ways. And if that means, for example, for low value disputes, that a less combative, more investigatory mode of dispute resolution is proportionate and delivers the just outcomes we require, we should be open to that, and we should be open to, as Sir Ernest Ryder said, to retrain the tribunal judges to conduct a different kind of hearing. That I didn't know, Hazel, about the relative costs, but I know there is enthusiasm in tribunal cases for the judges to be more participative. And it goes beyond case management. I rather euphemistically call it nudging, but actually it could be a far more participative process. And although I know that the adversarial system for many people is at the heart of the English justice system, if, as I say, our system isn't delivering the outcomes we require, we should be open, especially if it's not involving lawyers, to thinking, I wonder if there is a different way that technology enables us to reach just solutions. And it seems to me, just as our whole workforce is having to retrain in light of technological change, then so too judges might as well. So I've looked at this at length in my latest book. I don't see any fundamental jurisprudential difficulties in low value disputes to become less adversarial. The great Judge Jerome Frank in the United States talked about the difference between the fight theory of dispute resolution and the truth theory. And we live in the realm of the fight theory. Our disputes are a little bit of a fight, whereas arguably, at least, the inquisitorial investigatory system is trying to find truth. Seems to me finding truth is a rather good thing.
Thank you.
I think we're getting very deep here, but you are raising some really interesting questions. I think we're going to try Lord Howarth again and hope that his technological problems have been solved. We'll give you another chance, Lord Howarth, if you can come in now, please.
Well, thank you very much. Yes, I'll have another go if I may. I got some specific questions. When Professor Genn was praising the judges for their quick and positive response to the present crisis, she observed that they'd been doing this without training or equipment. But am I right in thinking that even as far back as 2016, HMCTS and the government announced a court modernization program and intention to move on a substantial scale to remote hearings? So how can it be that there was still no training or equipment? That's one question. You've both emphasized the need to gather appropriate data. I'd like to ask what your views are on how this should actually be done. Whose responsibility is it to establish the categories of data that are required and to ensure that that data is indeed gathered systematically? And my third question, the backlog in the Crown Court, 37,000 and rising even before the pandemic, short of moving to an inquisitorial system, short of moving to judge-only trials, which are very radical changes that would need extensive public debate, we're faced with a crisis about justice delayed and justice denied. Can technology, can remote hearings assist us in addressing this very urgent crisis that we have in the Crown Courts?
Professor Genn, do you want to come in first?
I'm sorry, because another technical hitch. I've discovered when my landline goes off, I get cut off from Zoom. I don't know why. I'll work that out one day. So I missed some of what went on, but I think I heard most of that. I think you were asking about whose job it is to collect data. So I think it's the job of HMCTS. I think it's the job of the Ministry of Justice. I think it's the job of independent research organisations. I think that I have to say that I believe that investment in research in the civil justice, the operation of the civil justice system has been extremely weak in terms of the availability of research funding for doing work on this. And I think this is a magnificent opportunity for people to do really high quality research and much, much needed research. And so it's the job of everyone. I think the court service is in a position to collect data that other people aren't in a position to collect. But I think it's the responsibility of a large number of organisations to do this. And I hope that perhaps possibly your report might be helpful in stimulating people to get on with that job. And the other question that you asked was about
the backlog.
Backlog and jury trials. Well, of course, because there have been so many adjournments, I've heard that actually some jurisdictions, in particular some of the tribunals, they're eating through their backlogs. I'm not sure how they're doing that, whether they're making decisions on papers or whatever, but some people are managing to clear historic backlogs very well because so many cases have been adjourned. But all we're doing is storing up a pent-up demand. As soon as lockdown ends, there's going to be a real flood of cases, and that's going to be quite difficult to manage. As far as Crown Courts are concerned, I'm not that familiar with the criminal justice system, so I don't know whether, Richard, you may have better information about what's planned for there. I know that there is the question of whether or not we should have judge-only trials is something that has been hotly contested for many, many years. And there are provisions for judge-only trials, and of course in Northern Ireland there have been diplock trials for years. But I know that is in general not popular. So, Richard, I don't know if you've got any thoughts on that.
Professor
while you were off, forgive me. While you were offline, there was another question, Lord Howarth asked. First one about how are the judges not better equipped and better trained? Because you're absolutely right. There's a £1 billion reform program going through the HMCTS are driving through just now. But in fairness, the technologies that are envisaged there are not necessarily the technologies that have been rolled out now. And so I think most judges would say that if you want to work effectively at home, you need more than one screen. Now, that's not something HMCTS had in mind. They are rolling out, of course, the cloud video platform, which is going to be an improved and generic video hearing environment, but that wasn't scheduled to come out quite yet, and so the training wasn't yet in place. So I suspect I'm less critical than you might be of the judges not having the facilities and the training of technologies that hasn't yet been made available to them. Being no doubt, though, the last 3 decades has been a massive struggle adequately to equip judges with appropriate technology. And hopefully this will accelerate the process. I think you very well expressed the dilemma for a criminal. If it's any comfort, there's other countries that have massive backlog. If I can take you to Brazil for a second, there's a backlog in the court system of Brazil extending to 80 million cases, not just criminal, but that gives you a sense this is a global phenomenon. But where I think you're so right is that a lot of the more radical steps we might instinctively think we could take would require extensive public debates. The jury trial goes to the heart of our feelings about what it is to be convicted in a public forum of some kind of crime. And I would be very nervous about having virtual jury trials, for example. I think, though, that there are preliminary hearings, there are, it seems to me, less serious crimes that we can imagine. And there's a very, on our website, the remote courts one is a very interesting case study by a magistrate who disposed of a minor criminal issue online. And when you read that, you think, well, actually, that just makes sense. So it does seem to me, certainly for lesser offences, we should be open to the idea of hearings done by video. But we face a major public challenge in how to cope with a massive backlog that will inevitably build up of serious criminal cases where people's liberty is at stake. And that, it seems to be, out of all of this, that's the great challenge that emerges.
Thank you. Right, now let's just move on. Lord Fawkes, you wanted to come back on the next dimension. Can we unmute Lord Fawkes, please? Can the technical people... He was unmuted for a moment, but then the mutes come back on. Can we take it off, please? Thank you.
Thank you.
Edward?
Thank you very much, Chair. I wanted to ask you about the position of online courts or remote courts and the media. It's, of course, very important that justice is seen to be done, and I should declare an interest as chair of the press regulation body. We know that there's a real problem with reporting of court proceedings generally, even in conventional form. But where you have virtual proceedings, it seems that there is a particularly acute problem in terms of the constitutionality of court proceedings not being seen. How do you think the balance should be struck between accessibility and transparency on the one hand, and the fact that there are rules which prevent you recording and transmitting proceedings?
Who would like to go first? Professor Susskind.
Yeah, open justice is another one of my categories of justice. I've talked about substantive justice, procedural justice. I've talked about distributive justice. Another pulling in a different direction, as you rightly said, is open justice, because you can imagine a cheap, fearful, quick system that's closed. And people would say, well, that there's a fundamental problem there. My starting point in the open justice discussion is that open justice does not trump all other arguments. We make decisions to hold hearings in private when there are issues of national security, where there are vulnerable witnesses. The decisions we've made over the years not to have cameras in the courtroom are decisions that suggest that open justice does not trump all values. I think it's terribly important, but I argue there's two aspects to open justice, and one that will become increasingly important. The first is what I call real-time transparency, the ability to go in and have a look at the justice system in action, to sit in a physical courtroom. And the second I call information transparency, which is the ability easily to find out about the justice system. In a democratic society, we should be able to find out the volumes of cases, the results of individual cases, when and where cases are being held, which parties involved, what judges are at play, and so forth. Today, we have, in the physical court system, quite a lot of real-time transparency, but very limited information transparency. Very hard for most people to find out what's going on in the justice system. And that actually weakens confidence in the system, that opacity. But it seems to me we're going to perhaps see the reverse. There might be less real time. You can't walk into a physical courtroom, but if we get our systems designed well, we should have far more information available. So I see definitely an increase in information as possible in an online environment. It's interesting you asked that question again today, because it was a question that was addressed, and you'll see in the Civil Justice Council's report, where I think it's fair to say that the media in general have felt that access to these video hearings has actually been at an acceptable level. And indeed, I've spoken to some journalists who say they could actually visit 2 or 3 different hearings in the one day at a time when that was technically impossible. And when you see in local newspapers the decline of the local court reporter, it will be possible to visit local courts, local in inverted commas, in the new world. That's a slightly different question from public access. And again, the court service has worked hard at offering access under certain conditions to members of the public to come and view. Technically, I believe certainly for video hearings, we can achieve both for the media and for members of the public increased transparency. When it gets to, say, online continuous hearings or hearings in the papers alone, that's a different matter, and that's something I've dealt with at length. But I suspect your question is more about the actual video hearings, and I'm saying with some confidence, not necessarily that in all cases today, over the last few weeks, that's been achieved, but as a matter of technology, I think we can increase access to justice, access to the actual experience of observing some kind of court process in action. So I respond quite positively and confidently to that one.
Professor Gann?
Actually, I don't disagree with that. The Civil Justice Council rapid review that's been done, I think that the reports from people in the media, they're actually very positive. And talking to people who've been involved seem to think that there are some real opportunities, and also the opportunities for the public, if it happens, that the public can actually watch what's going on in remote hearings, in a hearing that would normally be public. I think it will actually make it easier for people to see what's going on and to keep the judge under review as the judge does his job. So I think there actually could be some genuine opportunities for transparency, and as Richard said, transparency doesn't trump everything else, and we do have private hearing. So for me, that is not it's not my biggest concern.
Thank you. Baroness Coulson, were you trying to get in there? No. Okay. Let's move on then. Lord Wallace, would you like to come in now, and can we unmute Lord Wallace, please?
Thank you very much. I mean, I think that we've certainly found this a stimulating, thought-provoking session. And I think I glean from both our witnesses that when we're through this current crisis, it would be a mistake to go back to where we started before the crisis. And I think, in Professor Susskind's words, that we shouldn't be perpetuating the old inefficiencies. But I just wondered, if that being the case, what procedural, legal resource requirements do you think there are as we move to the future in terms of perhaps expanding or extending remote proceedings? And if there's a sort of supplementary to that, where you think there might be limitations, proper limitations, to use Professor Suskind's terminology, the remote courts?
Who'd like to go first? Professor Susskind.
Could I divide what I think needs to be done now into the medium and the long term? It seems to me in the medium term, we have to ensure, and I'm really hoping you can support this, that the experience of the remote courts informs, and where appropriate, actually leads to changes in the current courts and tribunals reform programme. I'm not stipulating what these changes need to be, but we have this massive ongoing programme costing us, the taxpayer, over £1 billion. A lot of it's premised on technology. A lot of it's premised on, I think, warranted assumptions, but we now have so much experience that someone has to, and I think there's early work on this, but someone has to take a step back and say, in light of this experience, what does this mean for the priorities, the direction of the reform programme? It's the most ambitious court reform programme in the world. It's something we should be proud of, but we have to make sure that the, I think, incredibly competent civil servants who are driving that programme are given the space not just to carry on driving it forward as previously articulated, but benefiting from this experience. Then longer term, we have the opportunity, I think, radically to redesign our court system and put in place a new configuration of people, of processes, of technologies, of physical spaces that I think on balance would be superior. It could be sustainable and accessible. I think it's wrong, incidentally, and we all fall into this trap, me too, of thinking in a rather binary way about physical courts or remote courts. Let me put it a slightly different way to you, that the court service should be a blend of a variety of facilities. Sometimes the court service will be in a physical courtroom. Sometimes it'll be in a video hearing. On other occasions, it might be a phone. On other occasions, it might be by paper alone. And our challenge is to take a step back and look at all the workload facing the court service today, extend that to the workload that Hazel points out, what I call the latent market, those people who need help but don't get it today, and do the analysis to find which of these techniques, in light of our experience, are best suited to that workload. So it's a huge process analysis needs to be undertaken so that we allocate cases and parts of cases to the most efficient resolution mechanism, consistent, as Lord Hennessy was stressing, with the delivery of substantively just outcomes. That's absolutely crucial for me. That I don't know if that helps by way of setting up Hazel to follow up, but that's for me, as I say, there's a medium term. Let's make sure the reform program's informed and changed appropriately, and then there's a long term. Let's, for goodness sake, not just default back to the old ways of working. Let's take the best of this, take our understanding, so we can actually deliver a better justice system.
Well, I think Professor Genn wants to come in, and then I'll bring in Lord Fawkes again, because I think he wants to follow up on something. Professor Genn.
Thank you. Just to say, at the risk of violently agreeing with Richard on one occasion, I think in the short to medium term, certainly we need to sort out the technology, but we need to make sure that we collect the data about what's going on, to review it, to keep it under review, to bake data collection into the architecture of our system, the systems that we're making. I like the idea of taking a pause and standing back and using this opportunity to ask ourselves some questions about this massive reform program that we were undertaking. And that at the end of the day, we can have a system that actually better meets the needs of the very wide range, the wide variety of users who use our courts and tribunal system. And that's why I started out with that we need to understand better what works best for whom, what kinds of circumstances, and delivers substantively just outcomes.
Thank you. Lord Fawkes, you wanted to come back in.
Yes, if I may. I, of course, entirely agree that when this coronavirus is over and we can, at least in theory, go back to where we were, we shouldn't ignore the lessons that we've learned. But perhaps both of you could confirm my experience, at least, is that even before coronavirus, the profession and the court system was, in fact, using technology in a number of different ways. And I wouldn't want the committee to get the impression that it was so conservative that it wasn't taking on technology in terms of facilitating settlements, having remote hearings. We can, of course, build on that. But I hope you'll agree that this isn't conservative, though the profession may be. There was in fact an accommodation of modern technology within the way it was practiced.
Could I say something on that?
Professor Again, yes.
Because absolutely, the profession has really in recent years started to embrace new technology. The problem for us is that the court system was not set up, had not been designed, and there had been no investment in the infrastructure, in the technological infrastructure of the court system that would make it possible for the court to move into a more modern world. So this kind of paper-heavy system and antiquated machinery that people were using. So that's why I started at the beginning by saying we were starting from below sea level when we had to deal with coronavirus, despite the reform programme. And we haven't had the investment in the courts that I think other jurisdictions might have enjoyed over the years. And so I would say the profession has probably been ahead of what the courts were able to manage because of the restrictions on the technology that they were using, and to some extent the skills of the judiciary and the way that they've been trained to do things. Richard's probably got a view on that as well.
Thank you. Professor Susskind, the last word.
Thank you. There are two uses of technology. I call them automation and transformation. Automation is use of technology to streamline, optimize, improve, sustain your old and traditional ways of working. Transformation is using your technology to allow you to do things fundamentally differently. For the last 50 years, both court technology and legal technology have been automation. It's not a criticism, it's an observation that lawyers and court service providers have grafted the technology onto our traditional ways of working. So we've been using technology to turbocharge our old ways of working, but that often in my unkinder moments, I think, gives us mess for less. It often takes a messy process and makes it slightly more efficient. The real strategic attraction of using technology in a transformative way, and we can see it in so many other sectors, from medicine to manufacturing and elsewhere, is that technology sometimes allows us to do things that previously weren't possible. And goodness me, can you imagine if this was 1990, before the World Wide Web was invented, before there was email, before there was even telephone conferencing of any significant sort? Our system would have ground to a halt. The technology has allowed us to deliver a court service in a way that previously wasn't possible. And that has got to be our watchword for the future. I'm not really interested in the use of technology further to streamline our processes, which go back to the 1870s or more distantly 900 years. I'm wondering in a digital society whether or not we might be able to resolve the very important disputes that our people have in ways that technology facilitates, entirely new ways. So you're right in a way that we've invested heavily in technology and there's been an openness, but I would argue it's the wrong kind of technology.
Well, thank you very much, and thank you to both of our witnesses, to Professor Genn and to Professor Susskind. It really has been very interesting, and I'm sure we'll want to follow up on many of the points that have been raised, and you've given us plenty of food for thought. So thank you very much indeed. And I close this session, and colleagues will now resume on another system. But thank you all very much indeed.